IX coordinator for New Mexico Highlands. Some of you will realize that that is a new position within our institution, and I'm filling a new role, as well as obviously the role of Title IX coordinator, which existed previously. So what is my role? I'm here for you to serve you as a one-stop shop to report potential violations of workplace laws. So that can include employment discrimination, retaliation. If you believe you're wrongfully rejected for an accommodation issue, a leave issue, wage and hour issue, anything that really connects to federal law is something that you can report to me. If it is not something that I can handle, I'll still refer it off, but really my role here is to be the person who can accept complaints about workplace conditions, particularly as they pertain to federal law. So some of you who are returning faculty know that normally during this time period, you receive Title IX training that is often connected with mandatory reporting training. And this year, I'm doing something different in focusing on anti-discrimination law and retaliation. Veronica, can I have the next slide, please? Here's my beautiful slide. Why aren't we having Title IX training? Well, the simple answer is that in May of this year, a very, very, very significant regulatory change occurred within Title IX. These changes affect a lot of different aspects of Title IX reporting, investigation, adjudication, and more importantly, there are 4 federal lawsuits that are challenging the new Title IX regulations as discriminatory, irrational, and attempting to stay in enforcement of those rules. The state of New Mexico, together with 17 other states, is a plaintiff in one of those federal lawsuits. So right now we have a lot of uncertainty about exactly what will happen. And as of today, we still don't completely know whether the regulations will be put into effect. Officially, the federal court, the implementation date is tomorrow. The federal court can still act after the implementation date. So right now, we don't know if the Title IX final rule, which is what it's called, will be implemented in full, in part, or at all. However, we do plan to provide more Title IX training going forward when the situation seems to settle down a little bit more. Furthermore, next slide, please, Veronica. Okay, so one thing that you can look forward to, it's not completed yet, is some interim guidance. Interim guidance will address certain topics that have changed under the Title IX final rule. One of those topics is mandatory reporting. Another is the definition of sexual harassment. And another is the standard of evidence. And the interim guidance, for those who are feeling nervous about all these changes, will help staff and faculty and employees of all kinds just move forward consistently with what we've done in the past. So as you can see, my fancy little green star, the interim guidance will continue the status quo you're familiar with. And it is not a policy, it's a recommendation, it's a guidance. It's there to help you guide your actions in this time when things are very uncertain. As many of you returning faculty know, policymaking has to follow a very comprehensive set of procedures. Faculty and staff input is required, presentation to the Board of Regents is required. It's time consuming. There are policies that our institution wishes to continue, like mandatory reporting, but making an official policy will be time consuming. So this is kind of like my quick and dirty explanation so that you guys can be oriented to what's going to happen. Now, I think there were some questions, and I just want to note that I'm going to move through my presentations, and if we have some time for questions at the end, I'll take questions at the end. There's a lot of material to cover, And even this is really an overview. Before we go to the next slide, I would like to poll my Highlands community and ask, have you received any discrimination or retaliation training in the last 5 years? Please note this poll is anonymous. I just want to feel the room. I don't want to, punish anyone who has or hasn't received training. So please take a moment to respond. Again, discrimination or retaliation in the last 5 years. Veronica, how long should we wait for responses?
I was gonna do about 60 seconds,
Okay.
which we are like 20 seconds in, or
Okay.
20 seconds from that end point. But we're doing good. And 3, 2, 1.
Okay, let's see the results. Okay, it's close to 50-50. That's really interesting. Well, I'm very glad that we are doing this training. I would like to mention this training is a preliminary training. It's to introduce concepts and is by no means comprehensive. Anti-discrimination law is quite complicated at times. And really what I want you as listeners, as participants to know is I want you to get your your sensors out for situations that might be reportable, or when a subordinate or a friend or a colleague may express an issue, that you know how to bring it to me, that it might be discriminatory. So let's, without further ado, move to the next slide, the definition of discrimination under Title VII of the Civil Rights Act of 1964. So here's our definition. It's a materially adverse, which means significantly negative, change in the terms and conditions of employment, which we will discuss, that occurs because of the employee's protected characteristic. So I've underlined these key terms because they're very important. This is a legal definition, and all the elements have a specific definition. So moving to the next slide, explains what a term and condition of employment is. Terms and conditions of employment in very practical terms are how you understand your job to be. It's what you understood the job expectations and the environment that you would work in, the type of assignments you would get. Terms and conditions of employment are varied by the kind of job that you do, right? Some jobs are 24 hours. Some jobs have defined work hours. But it always includes things. These are example lists. It's not an exhaustive list. These are the terms and conditions that are quite common and universal by hiring and firing, compensation, transfer and promotion, tenure decisions in the case of faculty, advertising for jobs, recruiting, testing, the use of facilities, training opportunities, different kinds of benefits, retirement plans, really just every aspect that you think of when you think about, hey, this is my job. So, and again, in order for something to qualify as discrimination under Title VII, there needs to be a materially adverse change in one of these terms and conditions. Next slide, please. All right. So another thing that Title VII also prohibits is harassment. So there's discrimination and there's harassment. Harassment comes in two flavors, quid pro quo and hostile work environment. Before I explain them further, well, no, I'll go through it. And the top two items, items 1 and 2, are the federal definition, and then there's an additional definition in New Mexico human rights law. So a quid pro quo is an exchange. It's Latin, it means this for that. And a quid pro quo to qualify as discrimination under Title VII has to be accompanied by a tangible employment action, either a tangible action for consent to submitting to the quid pro quo, or a tangible employment action for refusing to submit. And then the other flavor is hostile work environment, which is unwelcome conduct that occurs because of a protected characteristic and is so severe or pervasive that the workplace becomes intimidating, hostile, and offensive. Or, under New Mexico law, the conduct has the purpose or effect of unreasonably interfering with an employee's work performance. I would add that when it comes to discrimination law, the federal law is the floor, not the ceiling. A state may add additional protections, additional protected categories, additional definitions, as New Mexico has, and as New Mexico residents and employees, we're subject to both the federal and the New Mexico law. Some cities and municipalities additionally have their own laws. That doesn't affect us here in Las Vegas. So my next poll question is, can we have the next poll questions about the definitions? So my next poll question says, hey, many people know about these terms from discussions of sexual harassment, but do these terms apply only to sexual harassment?
Thirty more seconds. Three, two, one.
Wow. You guys all get an A+. 95% of you responded that these definitions don't only apply to sexual harassment. That's correct. Harassment can occur on the basis of any protected category. And we're going to discuss in the next slide what the protected categories are under federal law and New Mexico law. Sometimes it's hard to think. You're like, well, what kind of a situation would there be quid pro quo on the basis of ethnicity? Don't ask those kinds of questions, because I promise you somewhere, somehow it has happened. But regardless of how common or universal or expected, situations can arise. I've worked in employment law for a long time, and there is no limit to human ingenuity unfortunately, when it comes to harassment and finding new and unique ways to not be your best self. So let's go to the next slide, where we're going to look at the protected characteristics in federal law and New Mexico law. So at the top, you'll see that I have written that protected characteristics may be real or perceived. What does that mean? Well, protected characteristics can be the actual characteristics you have, the religion that you practice, the ethnicity that you identify with, your actual age, your actual citizenship or nationality. However, it is still discriminate, and perceived characteristics, on the other hand, are really based on false assumptions that people have made about you. They are equally illegal. If someone believes something about you that isn't true and chooses to discriminate against you, it is just as illegal as if you really were that thing. And the easiest, I think, one of the most common or easy to understand for people is if someone takes a negative action towards you because they believe you practice a certain religion, or they believe that you have some kind of disability. It doesn't matter if you have it or you don't. their choice to discriminate against you is still illegal based on their perception that you possess this protected characteristic. So let's look a little closer at the protected characteristics. There's quite a great deal of overlap between the two lists, especially because just in June of this year, the Supreme Court found that discrimination on the basis of sexual orientation or gender identity or transgender status is a form of discrimination on the basis of sex. So that was new this year in June. Previous to that, most states, like the state of New Mexico, had made sexual orientation and gender identity a specific protected characteristic. Yeah, it was some great news that we heard this year. The status of being pregnant, by the way, is also sometimes considered discrimination on the basis of sex or gender if it doesn't fall within the Pregnancy Discrimination Act. Age is a matter, it has to be over the age of 40. There are, the ADA, the Americans with Disabilities Act forbids discrimination on the basis of disability, which includes physical or mental disability. And then I would also note, it's written a little bit small, I hope you can read it, association with one who has a protected characteristic. So sometimes a person can experience discrimination not because they personally possess the protected characteristic, but because they are associated with one who does. So for example, the parent of a disabled child, the wife of a person who is over 40, right? Sometimes, and we're gonna get into this even more a little bit later in relation to retaliation, sometimes the discrimination doesn't occur directly, it occurs indirectly towards people who are associated with that person. Religion or creed, you can see, I would say that, remember, federal law is the floor, state law can be above that, but state law can never go below that, right? State law can never be less protective than federal law. So everything that applies on the left-hand side automatically also applies on the right-hand side. It's just that New Mexico can add additional protections. Let me just make sure I'm on the right slide. Okay, so remember, turning back to our definitions, materially adverse change in the terms and conditions of employment that occurs because of the employee's protected characteristic. Let's think about that phrase, because of, and how important it is. Okay, just because you have a protected characteristic, just because you are of a certain race, a certain color, a certain religion, a certain ethnicity, a certain national origin, doesn't mean that every act that occurs is related to those protected characteristics. Always remember because of, when you're hearing a story or a colleague has reached out to you for support, always listen for the because of. Why is this happening? If you believe that you, a subordinate, or anyone is experiencing discrimination because of a protected characteristic, you have the right to report it to my office. My next slide, please. Okay. This is very important. The term hostile work environment, it's a legal term. It's not a colloquial term. It has a specific definition. And it's important that everybody understand and not try to throw around this term when what they're really reporting is a workplace that they don't enjoy. So as a note, it doesn't mean an uncivil work environment. It doesn't mean an unhelpful work environment. It even doesn't mean a single instance of discriminatory speech. EEOC has said that petty slights, annoyances, and isolated incidents, unless they are extremely serious, do not break the law. They do not rise to the level of illegality. And even to take that to the next step, a generically toxic or abusive work environment is not a hostile work environment under Title VII unless it's because of a protected characteristic. It's a very valid legal defense. equal opportunity jerk, we call it. If someone treats everyone the same and the way they treat them is badly, it actually does not violate Title VII. It's actually a defense. So just remember that because of is very important when it comes to a Title VII discrimination claim. And lots of different court cases have made the statement and raised the issue that Title VII is not a civility code. It doesn't mandate collegiality or even being reasonable in the workplace. What it does forbid is discriminatory conduct. And that's, you know, sometimes hard to wrap your brain around, but that is the reality of the legal environment. Next slide, please. So if you're a supervisor, you know, what are you supposed to do? The first thing, of course, is never make an employment decision on the basis of a protected characteristic. If you're thinking about firing someone, don't say like, well, Joe is 45, so maybe we can get rid of him, right? Don't make it because of somebody's race, religion, veteran status, disability. Another thing is that if you witness or learn of discriminatory conduct that's either affecting you or it's affecting your subordinates, I would request that you report it to my office, to report it to me. You can also report it to HR, who will direct it to me. And if it's your subordinate who's reporting discrimination to you, always inform them that they have the right to make a complaint. You can ask them if, you know, they may say, please don't complain on my behalf, or they may say, please do complain on my behalf. The ball is in the person's court as what they choose to do, but always make them aware of their right to complain. And that it is my office, who is an independent investigating office, that will evaluate whether there's a legal claim of discrimination there. People don't have to use the word discrimination, and always remember that. Sometimes people say that things are unfair, and it's not completely clear what they mean. If you're in doubt, you can report the situation to me. I will, you know, reach out to the employee, find out what their concerns are, and find out if they wish to make a complaint. I think someone well, that doesn't matter. I would ask that don't start questioning people, don't begin an investigation. If you have a concern and you feel that it's not a fully fleshed out concern, like you might not have all the information, it's okay. You can just report it to me what you do know. It's better that you don't begin an investigation because a lot of, there can be a lot of negative consequences to an investigation that's started in a disorganized manner. First of all, people who are members of a union may have the right to representation and questioning. It's very important that that right is respected. And when you start asking questions informally, it can really create a gray area of whether that person was being questioned for discipline or not. So don't question people. If you have concerns, please report them to me. The other thing is that it can initiate a process where people start coordinating their stories instead of having an investigation that has a lot of factual integrity. It can get everything all scrambled up. So it's a best practice to report to me for investigation, as opposed to start hunting around for more facts. By the way, if you have some ideas about where more facts can be obtained, you can feel free to inform that to me if you make a report. I'm very open to that kind of information. But try to avoid doing an investigation on your own. We're going to move on to a hypothetical situation, which is the next slide. Okay, It's kind of lengthy. I'm going to read it out loud for the class. Jane Martinez is a professor of chemistry whose duties include teaching classes, supervising undergraduate chemistry lab sections, and reviewing the master's work of 2 graduate students. When the semester begins, Dr. Martinez is pregnant, but she prefers not to tell anyone. Towards the end of the semester, her pregnancy becomes obvious. One day, she is chatting with her chair, who says, "Congratulations on your pregnancy, Jane. Do you know when you're going on maternity leave?" Dr. Martinez says she hasn't decided. The chair says, "Okay, but don't forget your FMLA paperwork. Just let me know if I can help." Before the start of the next semester, Jane reviews her schedule and notices that there are no lab sections on her schedule. She asks the chair what's up, and the chair says, "Well, obviously you can't be in a chemistry lab since you're pregnant. It would be dangerous, and I don't want you or the baby to get hurt. I gave you an extra lecture section of Chem 101 instead. And anyway, you are going to go on leave, so what's the difference?" So the first thing, first question is, first poll question, please. This is
Hey,
the
Ruth.
protected care.
Yeah, it looks like all of the questions are going to come at once. Sorry, I designed it wrong. But is that okay?
Actually, it's fine, actually.
Excellent. Then I'm going to launch the polls. Thank you.
So once I've had, give you a little extra time, once everyone's had a chance to answer, we'll discuss the questions and the answers.
We'll give another 30 seconds.
Okay,
Ruth,
sounds good.
Max Baca is raising his hand. Would you like to address? Can I let Max speak?
Sure, while we're waiting.
Awesome. Yes.
Can you hear me?
Hey, Max.
Can you hear me now?
Yes,
I can.
Thank you.
Okay. So I see your answer, no. What's the liability for the institution for a workman's comp under this particular circumstance? Or do we have? Thank you very much.
Okay, so are you saying if the employee later claims that they are injured on the job?
Yeah, as a result of working in the chemistry lab, because to their right or not, either the management exercise the right instinct, like in this particular case, says you can't because you're pregnant. So do we have a for a workman's comp in the later?
You know, I think that there probably would potentially be a workman's compensation claim at the state level, you mean? I'm not 100% sure exactly what the liability is. However, the important thing about the Supreme Court's decision is that they basically said it's the pregnant woman's right to determine what is too risky for her to handle. In the actual case, United Automobile Workers versus Johnson Controls, the substances that the woman was working with were known to cause birth defects. And even despite that, the Supreme Court said that the employer can't dictate what kind of work an employee does. I'm not sure how workman's compensation works in relation to birth defects because they don't necessarily affect the employee, I mean. I would have to look more into what, if any, workman's compensation claim there is. It is not the employee directly in terms of their injury.
Thank you very much.
Yeah. Is the poll closed?
Yes, we're ready to share.
All right. Great. I think they're a great range of responses. And so in terms of number one, I think that perceived as disabled, it's a little less clear than the other two, pregnant and female, but it does appear that the chair may perceive that a pregnant woman is not capable of doing this work, right? That would be perceived as disabled. So I would say for me, the answer is all of the above, but it's not completely unambiguous within the hypothetical. So other answers could be reasonable as well. Now let's think about changing the classes. Changing the classes that Dr. Martinez is teaching, a change in the terms and conditions of employment if both were within her regular duties. The answer is that it can be. And we're going to talk about this a little bit more in relation to our additional slides about retaliation and kind of dig deep into what it means to change the terms and conditions. But generally speaking, if a change in workflow is because of a protected characteristic, then it can be a change in the terms and conditions of employment. It can be a very debatable and disputable fact within an actual lawsuit what the terms and conditions were. But if a person like Dr. Martinez has consistently had the same job duties over a long period of time, and all of a sudden they're changed because she's pregnant, that would be regarded as a change in the term and conditions of employment. Another factor the court sometimes considers is if some of the duties are more prestigious or more enjoyable or seen as grunt work or seen as low level, even though they're within your job description, if your job suddenly becomes predominantly the lower level work and hardly any of the higher level work, when that's a big change from what had been before, that can be a change in the terms and conditions of employment. Now with question 3, let's flip the hypo. What if the reason why the class schedule was changed was not Dr. Martinez's pregnancy, but because another professor suddenly quit and everybody had to fill in something? I would say yes, that does probably change the analysis. Because what's the because of? Why were her classes changed? Her classes were changed because of an overall schedule change in her department that affected a number of people. That would kind of point to that it was not because of her pregnancy. Like I said, just because you possess a protected characteristic doesn't mean that everything that happens is because of that protected characteristic. I think question 4 is actually very important. It's very hard for people to, it's sometimes, even though we have a very strong 88% response, sometimes it's hard for people to recognize that they may be engaging in discrimination even though they have good intentions. It doesn't matter that Dr. Martinez or that the chair wasn't trying to harm Dr. Martinez and really wished her well, liked her as a person, liked her as a professor and a faculty member. None of those things are relevant because, you know, there was a materially adverse change in the terms of her conditions of her employment because of her pregnancy. Obviously, that assumes that we didn't flip the hypo in question 3, that we stayed on the main hypo. So let's close these poll results. These polls are really enjoyable. I hope that you all are enjoying them too. I enjoy hearing people's thoughts, and we have only a very limited way of interacting within the Zoom. So thank you very much for participating. With that thought in mind, we're going to move on to the subject of retaliation. I know that that was a quick blitz through Title VII, and it's a very surface explanation, but retaliation is the subject I really want to focus on today. So let's move to the next slide. Everybody's probably learning about me that I enjoy purple and green together. So let's move on to the next slide. Okay, It's not only Title VII that forbids retaliation. Almost every law that affects workplace rights has an anti-retaliation provision. So we can look at Title VII. We can look at the Age Discrimination and Employment Act, the Americans with Disabilities Act, the Pregnancy Discrimination Act, Title IX of the Education Amendments Act, Occupational Safety and Health Act, Fair Labor Standards Act, that's wage and hour material, and all kinds of equivalent state level laws. It's, many people think a lot about issues relating to discrimination, but they don't think so much about issues related to retaliation. And that's one of the reasons why I want to bring this focus forward on my presentation. Let's go to the next slide, please. So once again, we see some of the same terms. Retaliation is an adverse action taken because the employee participated in a protected activity. We've already thought a little bit about what adverse actions are and what because means. Now we're gonna learn about, okay, well, we're gonna talk about adverse actions as well. All right, next slide, please. The definition of adverse action is really quite interesting. As you can see at the top, it says an employment action is adverse as a retaliation matter if observing it or experiencing it would discourage a reasonable employees from exercising their rights in the workplace. So that can be, in other words, that retaliation, an action can be retaliatory not only against an individual who, for example, made a complaint of discrimination, but it can be retaliatory towards others who observe that person's treatment. So it can include things like transferring the employee to a less desirable position against their will, engaging in verbal or physical abuse, harassment, or stalking, threatening to make or actually making a report to authorities, such as reporting somebody's immigration status. These are things that make people feel that it is not okay to make a complaint. Treating a family member negatively, for example, canceling a contract with the employee's spouse. We call that an association claim, same as discrimination. Making the person's work more difficult by purposefully changing their work schedule to conflict with family responsibilities that the employer knows of, or moving them to an office that's isolated from others that they work with. Now, again, we're going to talk about adverse actions have to come because of the protected activity. When we talk about retaliation, sometimes people have to be moved. Sometimes people's schedules have to be changed. It's why this happened. That is the important question. And let's go to the next slide, which explains what is a protected activity. So, a protected activity occurs when an employee does any of the following things in a reasonable belief that they are reporting a violation of the law, even if he or she does not use legal terminology, and also even if they're wrong, okay? It's very important. But let's look at the most common protected activities. Making a complaint in any form, filing a formal complaint, an informal complaint, an internal complaint, an external complaint, filing a lawsuit, any of which allege discrimination or the violation of some of the other workplace laws that we saw at the beginning. A person who made the complaint has engaged in a protected activity. No negative, materially adverse action should occur because they did that. Similarly, what's called a participation claim, being a witness or providing documents or providing physical evidence, aiding an investigation, aiding a lawsuit alleging discrimination, or telling a supervisor or manager about a violation of workplace laws. That's called participation. You're not the person making the complaint, but you participated. And then there's opposition. Opposition in most cases, it's a very interesting question from Eric Griffin, but I just want to get through my presentation and hopefully we can take a few of these questions at the end. Opposition in many cases has to do with speaking up. It can be refusing to follow directives or orders that would result in discrimination. If your supervisor directs you to do your job in a manner that's discriminatory and you refuse, that can be a protected activity. resisting sexual advances or intervening to assist others from sexual harassment or other forms of harassment, speaking up in the moment, and then to the question about whether my slides will be accessible, that yes, they will be later, at a later date. And then exercising your rights, such as actions like requesting an accommodation of a disability or religious practice, requesting a lactation space, asking your managers or coworkers about salary information because you believe that there may be some discriminatory wages going on. So these are protected activities, and it's very important to understand that when it comes to these protected activities, it does not matter if the claim is ultimately substantiated. You cannot retaliate about a person, or cannot retaliate towards a person who makes a complaint, participates, opposes, or exercises their rights, even if the complaint they made turns out unsubstantiated, right? It's really about the freedom of the individual to make a complaint. And the court has spent a lot of time thinking about this, and we're going to talk about some of the key cases where this adverse action and protected activity issue arises. Let's move to the next slide. Because of. Right, so not every adverse action is actually retaliatory. And retaliation occurs when the adverse action was motivated by the protected activity. And I think there was a couple questions about, is it hard to prove? Sometimes it is, sometimes it's not. It's a factual thing. Time nexus is one factor. The adverse action followed the protected activity closely in time. And I kind of know employment actions that actually precede the protected activity definitionally do not motivate the protected activity. So for example, if let's say that you are a person who gets terminated for cause, and then after you're terminated, you go to the EEOC and you make a complaint of discrimination. You can argue perhaps, my slides. You can argue that your termination was the result of discrimination if you believe that in good faith. What you can't do is argue that the termination occurred in retaliation for your report to the EEOC, because the termination came first, the complaint came later. Sometimes people say things. Sometimes they even put it in writing. It's very, yes. The portal timeout. We should be returning in a minute. Another factor that can point to retaliation being motivated by a protected activity is an evidence of a change in perception of the complainant, such as an employee who's rated very, very high for a period of time, and then immediately after the complaint receives a negative performance evaluation. I have seen all sorts of crazy things. I have seen people literally write on a performance evaluation, this person made a unsubstantiated claim of discrimination. Do not do that. A person's reports to my office, and their complaints of discrimination, internal, external, legal, court-based, they should never be an influence on a performance evaluation, whether you think that person was, very, very justified or very, very unjustified. All right, are we back with the next slide? Are we?
Almost.
Almost. Okay. So, yeah, and I really want to everyone to think about the fact that and we're going to talk about this additionally, it's very common, if you're aware that someone has made some kind of a complaint, whether it's to my office or the EEOC or the New Mexico state authorities, to basically have an opinion about how meritorious that type of claim is. You may know people involved. Having an opinion is very, very natural. But you got to be really careful, because your opinions about the merit of the individual's claim, they can lead you into retaliation quite easily. And we're so close to the next slide. And I'm actually, I wonder if there's time for, I don't have the chat questions available to me, or do I?
That is good. Are these the right slides?
Yes.
Excellent.
So, and I think there was a, this may touch on a couple of questions that were asked in chat, maybe not. There's a lot of myths and misunderstandings about what retaliation can really consist of. One is that retaliation isn't common. The reality is that it's actually the most common form of discrimination claim. Retaliation is much more common than discrimination, certainly within the court system. At one time, they actually narrowed the definition a few years back, because it was over 80% of the legal cases were retaliation. Basically, when they narrowed it, all they said was that the protected activity had to be the primary motivation, rather than just one among several motivations, which had been the rule in the past. But that was quite a few years ago. So another myth is that only a supervisor with supervisory authority can retaliate. That is not true. Any person with knowledge of the complaint can be seen to act in a retaliatory manner. So for example, this was in my previous, before I came to Highlands, I was an internal investigator for the New York City Fire Department. And it's quite common for there to be interpersonal confrontations in that work environment. And one of the things that we will always remind people is, like, going up to someone and saying your complaint was bullshit, that can be retaliatory. That can be viewed as an act of retaliation. And similarly, if the complaint was dismissed, you aren't retaliating. Again, whether or not the complaint was dismissed is not a relevant consideration in evaluating whether retaliation is occurring. And again, just speaking calmly can't be retaliation. It's not so simple. If what you said meets the standard that it would dissuade a reasonable worker from exercising their own rights, it is retaliation. So understand that this can really, is something you really need to keep in mind. And we're going to go to a hypothetical. Next slide, please. So Sheila White was the only woman working in the maintenance of way department of the Burlington Northern Santa Fe Railroad's Tennessee yard. She made an internal report that her supervisor was sexually harassing her, and the supervisor was disciplined after an investigation. But White was then moved from duties as a forklift operator to less desirable duties as a track laborer, even though her job classification remained the same and both tasks were within her duties. White filed a complaint of discrimination and retaliation with the Equal Employment Opportunity Commission. She then followed with a second complaint of retaliation, saying she was being excessively scrutinized by her manager. Soon after, she was accused of misconduct, suspended for 37 days without pay. Now, an internal investigation cleared her of misconduct, and she was reinstated with back pay. Now, I tricked you. This is a real case. This case was heard in the US Supreme Court, and by unanimous decision, they formulated the definition of adverse action you heard today, that it would dissuade a reasonable worker. The Supreme Court didn't find it extremely significant that White ultimately suffered no monetary loss, was only asked to do work within her job description, and was cleared of misconduct by her employer's own procedures. They focus more on the effect of the conduct on other workers than the effect on White. And what that means is, I'm going to go back, track back one backwards to the hypo, to slide 18. So think about what other employees saw. No, the next one.
Oh, sorry.
Yeah. When you're thinking about, you know, what was the Supreme Court so concerned about? Because ultimately, White wasn't really that harmed. They were thinking about what other employees saw and the effect on the mindset of other employees. So first she makes a report, internal report of sexual harassment. It's investigated, supervisors disciplined. That's great. It all went the way it should, right? But then employees see, the one person who made a report and got her supervisor in trouble suddenly gets a worse job, right? Then suddenly accused of misconduct, suddenly suspended. Regardless of how it ultimately shook out, you know, the average coworker doesn't even know how it ultimately shook out. They aren't paying attention. What they do know is they saw someone make a complaint, get a supervisor in trouble, and then lose 37 days of work, right? And that causes a reasonable employee to wonder if it's a good idea for them to make a complaint of harassment, right? And that's really why retaliation is such a big deal, because it impairs other people's rights to make their own complaints by making them fear for their job or their income or their position or their title, right? These actions are intended to punish, and they don't only punish the person who made the complaint. They punish everyone. They punish the whole community, actually. We're getting so close to the end of my time, and luckily, can we skip ahead to slide 20? And this is, yeah, we're not going to worry about the quiz questions. You guys are experts on protected activities now. Something that everyone really needs to understand is that most people don't set out to harm an individual with the specific idea like, oh, that person made a complaint, I'm going to retaliate against her, I'm going to make her life miserable. Maybe some do. I'm not saying it never happens, but retaliation often bubbles up from really strong emotions and feelings of unfairness, right? You may believe that the person who made the complaint is personally untrustworthy because of your own experiences with that individual. You may believe that the process that was utilized was not fair, and if the case was dismissed, it's because the process was flawed, right? All these things can happen. It's very important that you be when you learn about a discrimination complaint that may be affecting our community, be very conscious of your emotional desire for specific results. There's probably more information than you're aware of. And a lot of times when you may know individuals, and in a small community like Highlands, I would say more often than not we do know individuals involved in these matters and have opinions about them, either positive or negative. Understand that you may have heard stories that don't reflect all of the facts that are being evaluated. And especially what you read in a newspaper about a legal case is very rarely accurate or explained well. So please, when you're reading news articles, just take it with a huge grain of salt, right? Don't get fired up about what you read in the papers or hear in the news. Very rarely does it accurately reflect the legal questions involved. And it's just, the thing that I would just really like to say also is that as individuals, we have all kinds of personal experiences, right? And we have all kinds of intersectionality, as was kind of discussed in the diversity and inclusion presentation. We may have had negative experiences of our own. There is no inoculation or vaccination against retaliation. Even if you've been the victim of discrimination, it doesn't mean that you are incapable of retaliating, especially because most of the time it bubbles up from strong emotions. It's very important that you treat people who have made a report or a complaint the same in the workplace as people who have not. If you, have questions about a subordinate employee, how to handle a negative situation, a negative performance situation, you can reach out to my office. You can reach out to HR as well for support and the best way to handle that kind of situation. We do say that protected activities, they are not sword and shield both. a person makes a complaint, it does not mean they can never be disciplined for things that are reasonably violations of policy. And then, like, a lot of people ask me, what about false complaints? Some people make false complaints. Well, actually, intentionally, false complaints are quite rare. Most people who complain fully believe that a wrong has been done to them, whether that is rational or factual or objectively true or not, right? And we call that person has made a good faith complaint. Even if it doesn't have any factual backup, they believe they're complaining about discrimination, or they believe that they're complaining about retaliation. That's the legal standard, is to never discourage a good faith complaint. So even though it may be tempting to talk about the negative aspects or the facts that you know, like, oh, I know this person didn't do this, or I know that person didn't do that, just remember that the person who made the complaint is a good faith complainant if they believe that something's been done wrong. Confronting people and telling them that you believe that their complaint is either a lie, intentionally fraudulent, or anything of that nature, that is a very bad move. If you believe that there is some form of fraud or abusive process, you can reach out to me, but you should not confront the individual. You know, this, for a lot of people, I think there's a lot of emphasis on discrimination, but I really want people to be cognizant of retaliation as a really important thing that affects our community. And with the final slide, the very final slide, with 1 minute left to go, I would just leave you with the final thoughts. We each have a role in ensuring that every member of the university community feels that they're able to report violations of workplace and employment law. Second thought, the university is liable for your conduct when you break the law. And that's where the word compliance comes in. A retaliation case can cost hundreds of thousands of dollars, and I'm sure you can all think what you'd rather do with that money, right? So remember that you have a role in being a good steward of our resources. Actions that are retaliatory can also be misconduct. They can also result in you having discipline, and even ultimately to lose your job, depending on the severity of the conduct. So be a good steward of our resources, be a good steward of our community by respecting everybody's rights in the workplace. And that means respecting people's rights to make a complaint and participate in an investigation, whether you agree with them or not. And this here is my information for reporting. Ruth M is my username. People can't spell my last name. It's okay. My phone number, 454-3363. And just remember that each and every one of us has a role to play here. This is not something that comes on high. It's not something that only affects low-level employees. It affects every person, affects the community. And that, my God, I am finished.
Thank you so much, Ruth. I'm going to stop sharing screens. We do have a lot of questions. But because it is overtime and it has been a very long day, if it is okay, Ruth, I could share these questions with you and we can follow up with our community to answer these questions. Would that be
I think that's a
plan?
great idea. Yeah, that's a great idea.
Excellent, excellent. Well, thank you everyone for participating. We really appreciate your time. And like I said, we will take stock of the questions that are in chat, and Ruth and I will follow up with those answers. Have a really good lunch